specific, separate attacks on two witnesses and by attacking prospective jurors or juror, the defendant is nothing less than knowingly and willfully, that is intentionally, breaching the crystal clear, unequivocal lines set by this court in the April 1st order to protect the integrity of this proceeding. I am just going to talk a little bit about another argument that the defendant made in his papers where he claims that what he calls reposts are not his statements. In fact, some of his most dangerous statements, including one we brought to the court's attention as early as arraignments last year, that photo of the defendant holding the bat at the head of the district attorney, are what he wants to carve out of the order by calling them reposts. That flies in the face of common sense, and I am going to draw an analogy which is not perfect, but I think is helpful. New York defamation law has made clear for over 100 years that one who repeats or otherwise republishes a defamatory matter is subject to liability as if he had originally published it. That's Geraci versus Probst, 15 New York 3rd 336. And I can hand up copies if you liked. I will do that at the end. The court, sure. Mr. Conroy. Here we are dealing with a court order that specifically prohibits certain types of extrajudicial statements and that clearly includes posts on defendant's Truth Social account and on his campaign website, whether he is the original author, or posting the words of another, and as the court noted the other day, the law is clear that a party may not challenge a court's order by violating it. Your Honor, the judiciary law authorizes the court to impose a fine not exceeding $1,000 or to sentence the contemner to no more than 30 days jail or both in the discretion of the court. It is in Judiciary Law 751, and that's for each finding of contempt. We are not yet seeking an incarceratory penalty. The defendant seems to be angling for that. For today, for these 10 violations of this court's April 1st order, we are asking the court to impose the maximum number, $1,000 fine for each of the 10 violations. We are also asking the court to order the defendant to remove all 10 offending posts, 8 from his Truth Social account and 2 from his campaign website, to take those down. Finally, for the court to again warn the defendant that this conduct will not be tolerated and remind him that incarceration is an option should it be necessary. The defendant is having his day in court. Unfortunately, he is still doing everything he can to undermine this process. It has to stop. A finding of criminal contempt, imposition of sanctions, and stark warnings from this court are the minimum remedies necessary to try to stop the defendant from engaging in this behavior. Thank you. COURT. Thank you, Mr. Conroy. Counsel. Mr. Blanche. Thank you, Your Honor. There is, just to set the record very straight and clear, President Trump does, in fact, know what the gag order allows him to do and not allow him to do, and there was absolutely no willful violation of the gag order in the 10 posts and released by the campaign that the people just discussed. There is no dispute that President Trump is facing a barrage of political attacks from all sides, including from the 2 witnesses who are referenced in the early posts, and I am going to separate, Your Honor, if I can, the reposts from the first round of alleged violations involving the Avenatti comment and the comment regarding Mr. Cohen not being convicted of perjury and the comments about Ms. Clifford and Mr. Cohen. Okay. Those comments, those 3 posts, were in direct response to comments made by these witnesses, not about these criminal proceedings, Your Honor, not about their testimony at the witness stand, and President Trump's comments back to them was not about their testimony from the witness stand to the court. When you say, these 3 posts, just can we adopt the number used by the so I can follow them, prosecution? If you can refer me to this, what you are talking about. Mr. Blanche, the first was a repost from President Trump's Truth Social regarding Mr. Avenatti, commenting about the hypocrisy of the gag order and making the point that, which is true, that the witnesses themselves can constantly comment about whatever they want. They are not gagged. And President Trump, in theory, cannot respond. Now, as we put in our papers, and the people don't contest except to say there is no evidence from the truths that President Trump knew about these, Michael Cohen directly responded to this comment by Avenatti, politically. Not about the testimony. Not about what President Trump is going to say in court. So the court, do you have that? Do you have a copy of that? Your Honor, it's in our papers on Mr. Blanche, page 4. I can read it into the record, Honor. Court, sure. If you can tell me what time that was. Mr. Blanche, sure. 9:21, for 10 is the original post from somebody who says, to me, that Avenatti was thrown a Hail Mary on a pardon should the Orange Menace get elected. Mr. Cohen responds, he will be very disappointed as Trump will never pardon him because he doesn't care about him anyway. So, obviously, pardon is political. It has nothing to do with this case, Your Honor, and so, when President Trump comments about what Mr. Avenatti is saying, complaining about the gag order and a comment that Mr. Cohen has made about it, that's political. He is allowed to respond to political attacks. The court, I want to make sure I am following you. Going back to number 1, Mr. Avenatti's post was at 10:07 a.m. Can you confirm what time Mr. Cohen's post was? Mr. Blanche, don't have that in front of me. The court, it's just been handed to me. So, Mr. Cohen's post, I believe, was at 9:21, so that would precede Mr. Avenatti's post. Mr. Blanche, well, Your Honor, to be clear, Mr. Avenatti had been saying things like this publicly. There have been news articles about it that he had been saying it. So he has somebody on the outside, a federal person, that is pushing articles, and Your Honor, there is no dispute that Mr. Cohen has repeatedly talked about the fact that, again, not for having to do with his testimony about how President Trump acted with respect to pardons while in office. The court, I want to take one at a time, otherwise, it's going to get really confusing. Let's take number 1. What I see is Mr. Cohen's post at 9:21. Mr. Avenatti's response appears to be at 10:07, or is that when it was reposted by Mr. Trump? Mr. Blanche, yes, correct. The court, it was reposted by Mr. Trump. Mr. Conroy, believe that's correct. The court, and it's your position that what makes this political is the reference of being pardoned. Mr. Blanche, well, 2 things make it political. The reference to be pardoned, but also what President Trump writes in response to what Mr. Avenatti is saying, nothing about this case, Your Honor, but that they can do TV interviews, post on social, make money, have documentaries, all while talking about President Trump, but he is gagged and threatened with jail if he responds. Then, again, the social media posts he is referring to from these witnesses, the documentaries he is referring to from these witnesses, the money that they have made because of President Trump, the TV interviews, all of those things, Your Honor, while they certainly bring up the fact that they are testifying, they are talking about their very strong dislike of President Trump, their very strong desire for him not to win the election and for him to no longer be in power. The court, let's stick with what was actually said. I don't want to get into interpreting things. Stick with what was actually said. Going back to number 1. What is it about Mr. Cohen's post that makes it political? Mr. Blanche, well, Mr. Cohen's post talks about whether Mr. Avenatti will get a pardon. The court, so the pardon is what makes it political? Mr. Blanche, of course he's, Your Honor. Your Honor, says you don't want to interpret or read into it, but we have to be able to have some inference for what Mr. Avenatti means when he is saying that. Have you spoken with Mr. Avenatti, the court, about what he means? Mr. Blanche, no, of course, no. Court, how can you interpret what he means when you haven't spoken to him? Mr. Blanche, from his words say he doesn't talk about what Mr. Avenatti believes they are going to say on this witness stand or what happened in the charged conduct, says what they have been doing on TV, the social media posts, and on documentaries. The court, I just want to make sure I understand. You believe that everything that Mr. Avenatti said does not relate to the trial, but that the use of the word pardon by Mr. Cohen does make it political and, in a sense, authorize your client to respond? Mr. Blanche, not just the word pardon, but yes, the word pardon too. It's everything, Judge, it just when Mr. President Trump can't be a single word. Responding to these attacks, the court, when your client is violating the gag order, I expect more than one word. Mr. Blanche, Your Honor, we are here to determine, the court haven't determined anything yet. Am simply responding to what you are saying. You are suggesting that merely the use of the word pardon is sufficient to allow your client to violate a gag order. Mr. Blanche, no, that's absolutely not what we are saying, Your Honor. Absolutely not. What we are saying is President Trump is allowed to respond to political attacks. And more significantly, if he is talking about witnesses, it can't have anything to do with these proceedings. Judge, remember why that exists. The reason why this restrictive language in your order exists is from the D.C. Court of Appeals. As Your Honor will recall, the original gag order, the court, remember. Mr. Blanche, don't mean to relive that, but that's the point, is that in the D.C. Circuit in reaching its decision addressed why we are here today and said that there will be times when it is difficult to determine whether a statement concerns a witness' potential participation in the investigation or the criminal proceeding or a response to an attack, political, the court. That's why I am going to be asking you, in the same way I asked the people, for each one of their exhibits, to explain to me what made it political. I am going to ask to you, after each exhibit, what precisely is it that your client is responding to? Lead me to the attack he is directly responding to in each one of these. Mr. Blanche, he is responding to the fact that Mr. Cohen has repeatedly talked about his qualities and candidacy for office of the president. Court, there is no specific post that you are referring to? Mr. Blanche, no. The court, it is a repeated post. Mr. Blanche, that's where it refers to the actual language of the gag order, which is that so long as the discussion and comment isn't about the participation in this, it cannot be the mere time, meaning because it is a couple of days before the trial starts. That's it, beyond a reasonable doubt, that's willful. Right, meaning what I mean by that is Mr. Cohen, and particularly, and also Ms. Daniels, have ramped up their political attacks and their attacks on him as candidate in the weeks leading up to the trial as well. The court, it is the timing that has me a little bit confused. You referred to repeated attacks. Yet, this first exhibit didn't happen until, was it the day after the matter was brought to the appellate division? So your client waited until after, the day after the matter was brought to the appellate division, and the stay was denied, to decide if he would respond, not to a recent attack, but to a series of attacks. Can you rather understand why I am curious about that, responding a day before or 2 days before or 3 days before? Mr. Blanche, the timing of the response, Your Honor, appreciating it was a day after the appellate division, when we were in the appellate division, they were alluding to today. One of our main arguments was that we would be here for this kind of issue, that there was something ambiguous about what it would mean to attack a witness, a foreseeable witness, but, Your Honor, not about the criminal proceeding of why they are here. And so, Your Honor, I appreciate the question about the timing, but the timing is just the timing. And, I mean, President Trump chose repeatedly, all day, virtually 7 days a week, Your Honor, and by the way, well, we will get to the reposts in a moment, Honor, but the same is true for the court. Can we go on to exhibit number 2? Mr. Blanche, yes, Your Honor. So, again, this is a document, as the court knows, that's been in the public record and part of the public dialogue for many, many years. And I do not dispute the people's position that this document will be discussed at this trial potentially. No dispute there. But, again, you have a witness who is not talking about her testimony here, but talking about President Trump's qualifications for office and whether he should be president. The court, this was a response to what specific attack? Mr. Blanche, to, well, there have been again the court. You pulled this out and this is 6 years old when he pulled it out. I am assuming that there must have been a very recent attack to cause him to pull out a document that's 6 years old and was going to be used at trial. Mr. Blanche, it's not that it was pulled out. It is a public document. It's publicly available, Judge. Court, it says, look what was just found. Was that just found? Mr. Blanche, no, absolutely not. The court, so that's not true, that's not true? Mr. Blanche, that is not true. I don't think anybody thinks that's true. Everybody has seen the document for years and years. The court, whether somebody thinks it is true or not, I need to clarify and I need to understand what I am dealing with. Mr. Blanche, as we note in our papers, Your Honor, this is a document that is available to the public for years and years. And, yes, President Trump chose the words, look what we just found, it's true, is a communication to the folks that he is trying to message to. Again, not about the witness testimony at trial, but about her credibility. There is not a link between this document. The court, credibility really doesn't matter a whole lot on this unless she is taking the stand at trial, right? Mr. Blanche, Judge, that's not true. This is not true. Sure, her credibility will be at issue at this trial. Her credibility, when she is broadcasting to all of her followers on Twitter and talking to the press and having documentaries, her credibility matters, does matter in this courtroom. But he is running for president. He has to be able to respond to that. The court, all right, so that was exhibit number 2. I asked, again, what specifically he was responding to. I didn't get an answer to Mr. Blanche did answer you. Yes, I will answer you again. There was repeated specific. The court, give me one that's not specific. Give me one that he was responding to here. Mr. Blanche, yes, Your Honor. So there was, I don't have a particular tweet that it was responding to. What we included in our papers, Your Honor, is in addition to the documentary that came out, example which is very critical and, again, Your Honor, says that timing matters, right? Why? Court, I am asking the questions. Okay. I am going to decide whether your client is in contempt or not, so please don't turn it around. What I do see is I keep asking you over and over again for a specific example, and I am not getting an answer, and it's now almost 10:30. The jurors are going to be here at 11 o'clock. Don't want to keep them waiting. So we are only up to exhibit number 2. Mr. Blanche, the people got to speak as long as they wanted to. The court, the people were answering my questions. It's almost 10:30. We are only up to exhibit number 2. Let's go to exhibit number 3 and tell me what he was responding to in exhibit number 3. Mr. Blanche, Your Honor, exhibit 3 has nothing it's a complaint about to do with this investigation system, which President Trump is completely entitled to complain about, and the fact that there is a key witness in this case who is in prison right now for lying at a proceeding that Mr. Cohen also lied at. And, again, it has nothing to do with his testimony here. The court, he or his comrades, make the connection to what he is responding to in exhibit number 3 when he is referring to Mark Pomerantz. Mr. Blanche, he is asking whether Mr. Pomerantz has been prosecuted for violating grand jury secrecy rules. The court, why, pardon me. Why does he have to bring up a witness he knows is a witness? Mr. Blanche, no, Mr. Pomerantz is not a witness. The court, he is not on the witness list. I believe they are complaining. Mr. Blanche, know about this one, Your Honor, the third line down, has disgraced attorney and felon Michael Cohen been prosecuted for lying. That is what I was addressing when I said that the objection and the statement there has nothing to do with this case. It has to do with the system and the fact that President Trump very strongly believes that the people should have prosecuted Mr. Cohen for lying, just like they prosecuted the court, so he is attacking Mr. Michael Cohen's credibility just like he was attacking Stormy Daniels' credibility. Mr. Blanche, no, he is attacking the people and system for not prosecuting Mr. Cohen for lying. Right, look, that's been a theme that President Trump talked about repeatedly and for good reason. Seems that there are two systems of justice. Mr. Weisselberg is in prison and Mr. Cohen is going to be a witness. That's attacking the system, not Mr. Cohen. It's certainly the court, except that he makes the connection. The name that you refer to is Mr. Cohen. Mr. Blanche, it does mention him by name. That's not prohibited by Your Honor's gag order. The court, using the name is not prohibited. Making the connection to the trial is prohibited. Making a connection to the witness or the prospective jurors for the trial makes it prohibited. Mr. Blanche, I'm sorry, I didn't mean to interrupt. We are not making a connection to this trial at all. It says, disgraced attorney, Michael Cohen, has been prosecuted for lying. That has nothing to do with this trial. That is a question about whether he was prosecuted for his testimony in another case several months ago. The court, what caused that response? What was he responding to? Mr. Blanche, well, he is responding to the fact that he is extremely frustrated with the two systems of justice that are happening in this courtroom and he is entitled to respond to this. Whereupon, principal court reporter, Susan Pierce Bates, was relived by senior court reporter, Lisa Kramsky. COURT, two systems of justice in this courtroom, is that what you're saying? Mr. Blanche, that's what his message is, Your Honor, that Mr. Weisselberg is in prison and Mr. Cohen is not. That's not the first time that this has been said. The court, it's not. Mr. Blanche, no, it's not. And, Judge, as Your Honor has made plain, that's fair game. And as the law may explain and the Constitution may explain, that's fair game for President Trump to complain about. And to focus on the reposts now, if Your Honor wants to move to the reposts? The court, we can. Okay. Mr. Blanche, the court, just before we get to the reposts, when we get to each specific repost, just tell me what number you are referring to. Mr. Blanche, I'm referring to the remainder, many just two, the same posts just kind of reworked on of them a different either on truth or through the campaign. Judge, this goes directly to the willfulness that Your Honor has to find beyond a reasonable doubt for President Trump. There have been multiple reposts since Your Honor has imposed the gag order, and then the second gag order that the people have not complained about. And we mentioned a few in our papers involving the recusal motion and things that if the people felt or the court felt that a repost was violation, it's not a statement by President Trump. And so, Judge, it's that the court, no, I read that in your papers and I actually want to respond to that. Mr. Blanche, please. The COURT that suggests that somehow because the people or the court do not take action for every single violation that the gag order is waived, that's just silly. Mr. Blanche, that's absolutely not what we're saying. The court, no, it is what you're saying. No, first of all, you suggested that the court should do something. I think you understand the difference between what is a summary criminal contempt and what is not a summary criminal contempt.